disqualification. A person shall be see, ये disqualification अलग है और ये वाले grounds अलग हैं. So I'm already highlighting these points. A person shall be disqualified for being chosen as and for being member of either House of Parliament if he holds of any office of profit under the government of India or the government of any state other than the office declared by Parliament by law to disqualify its holder. So if anyone holds any office of profit, they can be disqualified. If he is of unsound mind and stands so declared by a competent court, if he is an undischarged insolvent, if he is not a citizen of India, very basic criteria, or has voluntarily acquired citizenship of a foreign country, or has showed acknowledgement of allegiance or adherence to a foreign state or let's say to an enemy state, and if he is so disqualified or under any law made by Parliament, किसी भी parliamentary law में अगर वो disqualify होते हैं, let's say RPA में disqualify होते हैं, then he will also stand to lose his membership or he will be disqualified. These are the members, and for the purpose of this clause, a person shall not be deemed to hold an office of profit under the government of India or state by reason only that he is a minister either of the union of states. So obviously we need to understand about the concept of office of profit, but this part. So these are the grounds on which disqualification can take place. But ये क्या कहता है? A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. Now, the ways in which disqualification will take place here and the ways in which disqualification will take place here is different. If he is disqualified under 10th schedule, this will be decided either by the speaker if he is a member of Lok Sabha or by the chairman if he or she is a member of Rajya Sabha. ठीक है? Just revising. I hope you know this. Decision on questions as to disqualification of members. So on all these matters, इन सारे मुद्दों पे, I'm highlighting this in black, from A to E, which is a part of first. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualification mentioned in the clause 1 of article 102, किसकी बात हो रही है यहाँ पे? A, B, C, D और E की बात हो रही है. I'll highlight this. Clause A, Clause B, Clause C, Clause D and Clause E of article 102(1). The question shall be referred for the decision of the President. So who will decide in such matter? The President will decide and his decision shall be final. So in these matters A, B, C, D and E, who will decide? The President will decide. President किसके कहने पे decide करेंगे? Election Commission के कहने पे decide करेंगे और जो भी Election Commission कहेगा President को वही decide करना पड़ेगा. There is no other way out for the President. Okay? See this. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. I am saying this statement. Tell me whether this statement is correct or incorrect. On matters of office of profit, the decision of disqualification will be based on the advice given by the Election Commission to the President. This is the first statement. And second statement, the President can deny the decision of Election Commission. Which of these two statements are correct? Tell me. What about the first? Is the first statement correct? Is the second statement correct? No. ठीक है? Is this clear? So this will be applicable to all of these. और 10 शेड्यूल अलग तरीके से काम करता है, वो आपको पता है क्या है. And same is provided with respect to members of state assembly. Same ही है, यहाँ पे भी यही है. A person shall be disqualified for member of legislative assembly or legislative council of state if he is so disqualified under 10 schedule. On all of these matters, on office of profit, unsound mind, undischarged, insolvent, not a citizen of India, disqualified under any law of parliament. इस केस में कैसे होगा? इस केस में if any question arises whether a member of house of legislature of a state has become subject to any of the disqualification, question shall be referred to the decision of the governor and his decision shall be final. But before giving any decision on such question, governor shall obtain the opinion of election commission. So here also the same situation, just that president is replaced by the word governor. Okay. Now, office of profit. Are you aware about the term office of profit? I hope so. Do I need to go through office of profit? Shall I skip? You cannot have more than one office, or you cannot have more than one official source of income. ठीक है? आप मेंबर ऑफ पार्लियामेंट और IAS ऑफिसर दोनों एक साथ नहीं हो सकते, मतलब आप दोनों का सैलरी एक साथ ड्रॉ नहीं कर सकते. स्किप. परफेक्ट. पढ़ लेना इसको. So Supreme Court has highlighted that in this case office must be under the government and tests are to find out whether the government makes the appointment, whether the government has right to dismiss the office holder, whether the government pays the remuneration, whether the duties are performed for the government, whether the government control duties and functions of the office holder, and are these functions performed any different from the one member already performed. So these will amount to then office of profit. Anti-defection थोड़ा important है, एक एस्पेक्ट बस इसका समझ लेते हैं. आई एम श्योर यू नो व्हाट अबाउट एंटी डिफेक्शन, इंट्रोड्यूस्ड बाय कॉन्स्टिट्यूशन 52nd अमेंडमेंट, एडेड इन द 10th शेड्यूल, बट इट डील्स विथ, इज एप्लीकेबल टू इलेक्टेड मेंबर्स ऑफ पॉलिटिकल पार्टीज, इंडिपेंडेंट मेंबर्स एंड नॉमिनेटेड मेंबर्स. क्लियर? तीनों पे अप्लाई होता है. कैसे अप्लाई होता है देखते हैं. टू इलेक्टेड मेंबर्स, if they voluntarily give up their membership of such political party and the word political party is mentioned in the Constitution of India, if he or she votes or abstains from voting in such house contrary to any direction issued by his political party, this is referred as whip, also provided in your magazine, please go through that. Whip is basically a direction issued by a political party. So let's say पॉलिटिकल पार्टी इश्यूज विप, तो अगर विप इशू कर दिया तो उस पॉलिटिकल पार्टी के मेंबर अपने पार्टी लाइन से अलग जाके वोट नहीं कर सकते. ठीक है? जो अलग जाके वोट करेंगे दे स्टैंड डिस्क्वालिफाइड अंडर 10th शेड्यूल. These two are important, independent and nominated members. An independent member of a house elected without being set up as a candidate by political party, मतलब उसको किसी पॉलिटिकल पार्टी ने टिकट नहीं दिया, वो खुद से लड़ा और जीत गया, becomes disqualified to remain a member of the house if he joins any political party after such election. So if an independent member wins the election and then joins any political party, he will stand disqualified. Whereas for nominated members, a nominated member of a house becomes disqualified for being a member of the house if he joins any political party after expiry of 6 months from the date on which he takes his seat in the house. So इनके लिए क्राइटेरिया 6 मंथ है, इनके लिए कोई महीना नहीं दिया है. जस्ट दैट फॉर इंडिपेंडेंट मेंबर दे कैन नॉट बिकम पार्टी और they cannot join any political party. This means that he may join any political party within 6 months. So it says a nominated member of the house becomes disqualified for being a member of the house if he joins any political party after the expiry of 6 months. So a nominated person can join a political party within 6 months. This is again provided in your See this question asked in 2022. See, with reference to anti-defection law in India, consider the following statements. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. Tell me. First statement, nominated legislature cannot join any political party within 6 months. Nominated can join a political party within 6 months. Second, the law does not provide any time frame within which presiding officer has to decide a defection case. True. कोई time frame नहीं दिया है, and this is a problem. Which of the statements above are correct? B. Which one of the following schedules of the Constitution of India contains provisions regarding anti-defection? Very straightforward question, I hope. So here regarding the whip के बारे में देख लेते हैं. It says inherited from colonial British rule, currently all parties can issue whip, and basically the 10th schedule effectively legitimized the issue of whip, because based on the whip they can now declare a particular member as disqualified. Written order from a political party to its members to be present for voting or to vote in a particular way, mentioned neither in the Indian Constitution nor parliamentary statute. हाँ, whip के बारे में लिखा नहीं है कहीं पे, but effectively we can say that the 10th schedule has legitimized it. Changes after the 91st Constitution Amendment Act, exemption from disqualification in case of split by 1/3. Earlier merger was possible and now it requires at least 2/3. So this is one change.